I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding that any statement I will make may be used against me.
When we interrogated the defendant last night, he confessed and wrote this document, which I have entered as evidence of the defendant's guilt.
Objection! My client's confession is in direct violation of the Fifth Amendment and should be discounted as evidence. Overruled. Officer Cooley, I would like to ask you some questions regarding your procedure for obtaining admissions of guilt. Did you warn him of his rights?
Yes, sir. At the heading of the statement is a paragraph typed out, and I read this paragraph to him out loud.
Is it not your practice to advise people you arrest that they are entitled to an attorney before they make a statement?
No, sir.
Was it not the Supreme Court's ruling that a suspect is entitled to an attorney at the time of arrest in Gideon v. Wainwright? Therefore, this confession is not valid.
Overruled.
The jury finds Ernesto Miranda guilty of murder and is sentenced to 20 to 30 years of imprisonment.
It is the opinion of the court that no confession can be admissible under the Fifth Amendment Self-Incrimination Clause and Sixth Amendment right to an attorney unless the suspect has been made aware of his or her rights and the suspect had then waived them. The person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent and that anything he says will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have the lawyer with him during interrogation. If he cannot afford one, a lawyer will be appointed to him. If the individual indicates at any time prior to or during questioning that he wishes to remain silent, the interrogation must cease. If the individual states that he wants an attorney, the interrogation must cease until an attorney is present. At that time, the individual must have an opportunity to confer with the attorney and to have him present during any further questioning.
A statement to make.
I would like the state of Texas to repeal the law against abortion because it's my constitutional right to choose abortion if I feel that's what's right.
The state of Texas calls Jane Roe to make her opening statement.
I would like the state of Texas to repeal the law against abortion because I feel it's my constitutional right.
I feel the unconstitutionality of abortion in no way violates a woman's right to privacy.
The court declares the abortion statutes void because they are too vague. The plaintiff's 9th and 14th Amendment rights are overbroadly violated.
This is outrageous! I want an appeal!
The court declares abortion to be a fundamental right under the United States Constitution. The court's interpretation of the right to privacy found in the 9th Amendment is broad enough to address a woman's decision whether or not to terminate her pregnancy. The government's interests are ensuring the health of the mother and the child. Therefore, during the first trimester, when the procedure is safer, the decision to abort must be left to the mother and her physician. The state has the right to intervene before the fetus is viable in order to protect the mother.
Darn it. The jury finds that Troy Leon Gregg guilty of 2 counts of armed robbery and 2 counts of murder. Gregg will receive the death penalty.
Objection! This death penalty is a violation of Mr. Gregg's 8th and 14th Amendment rights and is an example of cruel and unusual punishment.
The court finds the first sentence to be cruel and unusual and must cause excessive and unnecessary pain. Therefore, the jury does not find that the death penalty is unconstitutional. You can only decide once you have established one of these facts. 1. That the offense of murder was committed while the offender was engaged in the commission of the 2 other capital felonies. 2. That the offender committed the offense of the murder for the purpose of receiving money and the automobile described. 3. The offense of the murder was outrageously vile, horrible, and inhuman, and that they involved the depravity of the mind of the defendant.
Finding the first and second of these circumstances, the jury returns verdicts of death on each count.
Ah, what the?